Hi, my name is Ndukan Joku. I'm your lecturer for PUL 445 Evidence 1. Today we are continuing with our lecture on presumptions. In the last lecture we discussed the concept of presumptions and we looked at the underlying rules of presumptions and looked at the different types of presumptions such as presumption of law and presumption of fact, rebuttable and irrebuttable presumptions. But today we are looking at specific presumptions such as presumption of death, presumption of marriage, presumption of legitimacy and all that. I hope at the end of the lecture you will enjoy it. Thank you.
I hope at the end of the lecture you will enjoy it. Thank you.
Once again, you are welcome to today's lecture. We are trying to examine some specific presumptions. At the end of this lecture, you should be able to discuss specific presumptions and analyze those specific presumptions. Let us look at presumption of death. By virtue of section 164 subsection 1 of the Evidence Act, the court should presume the death of somebody who has not been heard from for a continuous period of 7 years. The section says that a person shown not to have been heard of for 7 years by those, if any, who, if he had been alive, would naturally have heard of him, is presumed to be dead unless the circumstances of the case are such as to account for his not being heard of without assuring his death. But there is no presumption as to the time when he died, and the burden of proving his death at any particular time is upon the person who asserts it. Now, subsection 2 of that particular section says, for the purpose of determining title to property, where two or more persons have died in circumstances in which it is uncertain which survived the other, they are presumed to have died in order of seniority. There is no presumption as to the age at which a person died who is shown to have been alive at a given time. So by virtue of section 164 subsection 1, if somebody has not been heard of for a continuous period of 7 years by those, if any, would have heard from him, that person is presumed to be dead. But there are certain conditions that have to be met before that presumption will be admitted. If we look at the case of Chad versus Chad, it was held that for that presumption to apply, the following must be shown. 1. That the person had not been heard of for a continuous period of 7 years. There existed people who would have heard of him. 3. That due inquiry was made by those people to no avail. So, for this presumption to apply, the person would not have been heard of for a continuous period of 7 years. So if, for example, the person was heard of perhaps 5 years ago, and then he comes back and people now sees him, then he travels out again or goes out again, that presumption has not been met. For this presumption to apply, it must be a continuous period of 7 years. The person would not have been heard of. And there will be people who ordinarily would have heard of him if he was alive. For example, his parents, his brothers, his sisters, the husband, the wife, the friends. These are people who would ordinarily have heard of him, of such a person, if he was alive. Let us look at presumption of legitimacy. Presumption of legitimacy. By virtue of section 165 of the Evidence Act, that section provides that without prejudice to Section 84 of the Matrimonial Causes Act, where a person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after dissolution of the marriage, the mother remaining unmarried, the court shall presume that the person in question is the legitimate child of that man. So if a child is born during the continuance of a valid marriage between the mother and the man, the law assumes that that child is the legitimate child of the man. If the marriage between the parties has been dissolved and the woman does not get married within a period of 280 years, 80 days after the dissolution, any child born within that period, the law assumes that that child is the child of the man. Now, of course, this is quite rebuttable, and it can be rebutted by scientific evidence. Now, in this class activity, you'll be required to discuss presumption of death from 7 years absence. Let us look at presumption of regularity, and that is provided under Section 168 of the Evidence Act 2011. Presumption of regularity. Subsection 1 of that section provides that where any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. So if there is an official activity or an official act has been done, and that official act or that judicial act was done in a substantially regular manner, then the law will assume that the formal requisite for its validity have been complied with. Then the burden will then shift on that person who believes or who is contending that the formal requisite for the validity of that official or judicial act has not been done to prove same. By subsection 2, the section 168 provides that when it is shown that the person acted in a public capacity, it is presumed that he had been duly appointed and was entitled so to act. If somebody acts in a public capacity and people deal with him in that regard, then it will be presumed that the person was appointed through a due process and entitled to act, because the person dealing with him may not know that the person was not properly appointed, if that is the issue. So the law then presumes that if somebody deals with somebody, a public official, in a public capacity, the law would then believe that the person dealing with him should presume that he was duly appointed. By subsection 3 of that section, it says when a person in possession of any property is shown to be entitled to the beneficial ownership of it, there are presumption that every instrument has been executed which it was the legal duty of his trustees to execute in order to perfect his title. So when you are entitled to a beneficial ownership of a property and that property is in your possession, then the law would presume that all the necessary instruments which ought to have been executed, which ought to have been made in your favor, has been done. Subsection 4 provides that when a minute is produced purporting to be signed by the chairman of a company incorporated under the Companies and Allied Matters Act and purporting to be a record of proceeding at a meeting of the company or of its directors, it is presumed until the contrary is shown that such meeting was duly held and convened, and that all proceedings at the meeting have been duly had, and that all appointments of directors, managers and liquidators are valid. So if there's a meeting, a company registered under the Company and Allied Matters Act, then the law will presume that all that was done with respect to that meeting or contained in that meeting were properly done. Of course, this is also rebuttable. Let's look at presumption of marriage. Let's look at presumption of marriage. By section 166 of the Evidence Act, when in any proceeding, whether civil or criminal, there is a question as to whether a man or woman is the husband or wife under Islamic or customary law of a party to the proceeding, the court shall, unless the contrary is proved, presume the existence of a valid and subsisting marriage between the two persons, where evidence is given to the satisfaction of the court of cohabitation as husband and wife by such man and woman. So, if there is an issue in a criminal trial or in a civil trial as to whether somebody is a husband or a wife under Islamic or customary law, the court can presume that there is a valid and subsisting marriage between the two persons. But this is of course rebuttable by evidence. But until and unless this presumption is rebuttable, then the law will continue to presume that there is a valid marriage between the parties. Let's look at genuineness of certified copies, and that is contained under section 146 of the Evidence Act. It provides that the court shall presume every document purporting to be a certificate, certified copy, or other document which is by law declared to be admissible as evidence of any particular fact, and which purports to be duly certified by any officer in Nigeria who is duly authorized in that behalf to be genuine, provided that such document substantially in the form and purports to be executed in the manner directed by law in that behalf. The court shall also presume that any officer by whom any such document purports to be signed or certified held when he signed it the official character which he claims in such document. So if the document is certified, the law will presume that that document is genuine, especially if that document is certified by an officer who is duly authorized to certify such document. And once that individual, that officer certified that document, the law will then presume that that person had the capacity or was duly authorized to sign or certify that document. And the next slide, you will be required to provide an answer to the class activity. Discuss presumption of marriage under the Evidence Act 2011. In today's lecture, we have looked at some specific presumptions, such as presumption of death, presumption of regularity, presumption of legitimacy, and presumption of marriage. I hope you enjoyed today's lecture. Thank you.